Fourth oral question, Baroness Butt of Solihull.
I beg leave to ask the question standing in my name on the order paper.
On the 31st of December 2024, 695 unreleased IPP prisoners with 10 years or more over tariff, representing 67% of this population. Data on the number of recalled IPP offenders who have served 10 years or more over their tariff is not centrally collated. On the 30th of September 2024, 2,320 IPP offenders on licence were 10 years or more over tariff, representing 80% of those in the community. 1,742 licences were terminated on the 1st of November following the commencement of reforms in the Victims and Prisoners Act 2024.
I thank the Noble Lord for this answer, and I know how hard he's working on this issue. And I appreciate that some of the answers I asked for are not collected, but nevertheless, the fact remains that almost 700 IPP prisoners who've never been released from prison have been locked up for more than a decade longer than their original sentence indicated. Most of them because their mental health is in such a terrible state. Does the Noble Lord, the Minister, accept that in many of these cases it was the IPP sentence itself that broke their mental health, trapping them in a self-perpetuating nightmare? So does he agree that resentencing these prisoners with appropriate safeguards and help is the only way to rid this country of this terrible stain on our justice system?
I thank the Noble Baroness for her question and also for the interest she has in this really important area. And I want to assure her and all Noble Lords that I'm not giving up on anyone. So far as mental health goes of IPP prisoners and all prisoners, the Chief Medical Officer has agreed to include consideration of the IPP sentence in his independent review of offender health this year, which I'm really pleased about. And when it comes to resentencing, public safety has got to come first, and the parole board are experts in deciding who is safe to be released and who's not. That is why the IPP action plan is absolutely vital, and we need to make sure we keep making good progression on it.
My Lords, like many others, and indeed the previous speaker, I believe that resentencing is the only way to wipe the IPP stain off our justice system for good. But the government has just been mentioned there are worried about the overruling of the parole board. So therefore, does the Noble Lord the Minister agree that initially limiting resentencing to those already living on licence in the community fully addresses this objection? Because the parole board has already decided that they're safe for release.
I thank my noble friend for his question. Those in the community are already benefiting from the significant changes to the IPP licence period in the Victims and Prisoners Act 2024, which provides an avenue for an earlier end to the sentence after a successful period in the community. Resentencing those living in the community would halt the risk management and support provided to these individuals, some of whom will be at the critical moment of being recently released from custody. And although this is not a good example of someone who's been released, every prison I go to, I always ask to meet an IPP prisoner and sit in their cell or sit in an office and talk to them and find out what their situation is. And recently I met an IPP prisoner who's 11 years over tariff. He's spent 8 years at Rampton Hospital, and he is not engaged at all in his sentence, and the action plan is not working for him. That's why it's really important that we need to give people hope, and the action plan, for me, is the way to do that.
Building on the previous question, there are many IPP prisoners who've been considered safe to be released by the parole board and been released, but then recalled to prison other than for a further offence. So are the government considering whether different considerations perhaps come into play here in respect of these released and then recalled IPP prisoners, previously considered safe to be released, in terms of risk assessment and the possibility of future release?
The Victims and Prisoners Act, which I mentioned already, in 2024 introduced a new power to enable the Secretary of State to release recalled IPP and DPP offenders using risk-assessed recall review, where safe to do so, without the offender requiring a release decision from the parole board. We now consider every recalled IPP and DPP offender for RA, as it's called. This has already been used to enable swifter release, and in some cases, we've seen recalled IPP prisoners released several months ahead of their parole hearing. And I know the noble Lord will know, but not everybody who is recalled to prison as an IPP prisoner, the 30% of IPP recalls are because of a further charge for an alleged offence.
My Lord, the government declined to do anything radical to end the Orwellian system of IPP sentences because it's concerned about public protection. Obviously, we all are. But there is no absolute guarantee that non-IPP prisoners will never re-offend. So why pursue this unrealistic goal for IPP prisoners and thereby trap them in a limbo which is rightly described not only by my noble friend but across the political spectrum as a terrible stain on our criminal justice system?
I agree with the noble Baroness that it is a terrible stain on our justice system, and in the job that I'm doing, it's my job to make sure as many IPP sentenced prisoners engage with the action plan and get release and stay out and not come back. In 2024, the number of IPP unreleased fell by 182 and recalls fell by 83. But noble lords will, I'm sure, be aware that we're dealing with a number of issues in our prisons at the moment to do with a lack of capacity. And so we're trying to battle to make sure that we get prisoners in the right prison to engage with the action plan, and hopefully they get out and stay out.
My Lords, given that...
Taking into account all that's been said already, I do welcome the enactment of provisions in the Victims and Prisoners Act passed by the last government, allowing termination of licence conditions for IPP prisoners. However, there are huge legal complexities involved, and I wonder what steps the government's taking to ensure those eligible for termination of their licence conditions actually understand their rights and are able to exercise them.
I thank the Right Reverend Prelate for her question, and I agree with you that I've met IPP prisoners, both in prison and the community, who aren't fully aware of the situation they're in and what they need to do from here. So I think you raise a good challenge to me and my colleagues in the Ministry of Justice, which I will take away and reflect and get back to her.
My Lords, given so many...
The Lord Warder next.
My Lords, given that so many of those prisoners serving this sentence who have never been released are suffering from chronic mental illness, is it not time for them to be considered for transfer and treatment in a mental health setting and not in prison anymore? And I mean that systematically and not simply ad hoc, as when individuals are transferred, as I know some are, to a mental prison. And in that connection, what consideration has the government given to the proposal from the Royal College of Psychiatrists for the development of a regime parallel to Section 117 of the Mental Health Act to offer support to these people if they do achieve release through that route?
There are 241 IPP prisoners in secure mental health settings as of our last figures that have been published. And it is those that are of real concern to me because they are so far away from being safe to be released. But what we need to make sure we do is to support them, and the example that I gave earlier on of the prisoner that I met recently, to support them on their journey. And I think the work that the government is doing on the Mental Health Act with the provisions being put in place will hopefully contribute to a more successful outcome.
My Lords.
My Lords, we'll have Lady Baroness Fox next.
My Lords, following on from Baroness Burt's request for more detailed data, can I ask the Minister, will the government make public detailed data of the different gradations of risk presented by the various cohorts of IPP prison population, assuming they aren't treated as an undifferentiated blob? And then could the government apply the same risk assessment criteria used for early release decisions to the least risky IPP prisoners and release them now, hardly early, Because to exclude IPP prisoners from emergency measures to ease overcrowding seems irrational, even cruel.
The noble Baroness will be pleased to know that I've raised this when we had the Peers Roundtable a few months ago, and I'm hoping to have another one in May, when we talked about the RAG rating of IPP prisoners. And at the time, we just RAG rated those in prison, and I'm pleased now that everybody in the community is also RAG rated, which will help. And I'm hopeful that noble lords will suggest to me what they would like on the agenda for our roundtable, which will hopefully be in May. And maybe when it comes to data and the important questions around data, that's something we could discuss then.
My Lords, that concludes oral questions for today.